Our next speaker is Edith Hakola. She's Executive Vice President of the American Unity Legal Defense Fund, and she directs the research and legal program focusing on immigration issues. She also served as Vice President and General Counsel of the National Right to Work Legal Defense Foundation and was appointed by President Reagan to the Council of the Administrative Conference of the United States. She is a graduate of George Washington University and the University of Richmond Law School. She was professor of law at the Delaware Law School and is a member of the bars of Virginia and the District of Columbia, the United States Supreme Court, and the United States Court of Appeals for the 4th, 8th, and 10th Circuit.
I'd like to share with you a report on the American Unity Legal Defense Fund, and also some of my ideas from my experience in the public policy arena in general, and specifically from working with the Right to Work organizations, long-established lobbying and legal defense fund. There are many parallels between the Right to Work efforts and the efforts to change immigration policy. State right to work laws exist only through an exception to federal preemption under the National Labor Relations Act. In immigration, state and local police powers are an exception to federal preemption of immigration law enforcement. Both issues involve national, state, and local action in areas where the federal government has fallen down. For example, my first direct action with the Right to Work organization came when we placed a Right to Work law on the ballot in Oklahoma. Our key staff people lived in Oklahoma for months of intensive field work attempting to pass that law. It's very much like what is happening in immigration in Arizona and elsewhere today. We lost the referendum primarily because a court challenge delayed the issue on the ballot. We couldn't get it on for a year, at which point the opposition had done a great deal of work in the state. Our opponents, directly and indirectly through front groups, were working to change public policy with court action. This stimulated the establishment of a right to work legal arm. Lobbying is essential, but court action is equally important. All of our lawyers agree. The courts interpret the meaning of laws that the legislators pass. While the legislative battle continues, the immigration battle is also moving to the courts. As with lobbying efforts, there are many possible actions and limited resources, and we've heard some today, quite a few today. As states and localities pass laws, opposition organizations like MELDAF et al. And big business associations are filing legal actions to block them. We all know there's more to do than people and resources to do it. That's very true in immigration. It's important to monitor and select the issues that may have the most impact and continuing monitoring as opportunities arise and change. The American Unity Legal Defense Fund is monitoring litigation and taking action. In 1999, when the Center for American Unity began operations, the center's focus was to launch Peter Brumlow's internet magazine, Vidare.com. The next year, we learned about a Michigan housewife who had been convicted of a felony and jailed for forcefully voicing her wish that people would speak English in the United States. The Center and Pro-English filed a brief on the constitutional free speech issue, and John Rowe was our pro bono local counsel. Thank you again, John. And Peter and I were in the Michigan Appeals Court for the argument. When the judges asked Mrs. Barton's attorney to explain the constitutional argument, he turned to us and told the court that the center had briefed that issue and the center's attorneys were in the court. There's no question the Amicus Brief and the interest we showed by traveling to the argument helped win that case for Mrs. Barton. You've heard a bit about the Hamdi case this morning. In 2004, we filed an amicus brief in the Hamdi case to raise the birthright citizenship issue at the Supreme Court. Hamdi was an enemy combatant who claimed American citizenship because he was born in Louisiana. Barnaby Zoll, who many of you know, wrote the brief and also talked with the Justice Department attorneys, who then changed the description of Hamdi in their brief to a presumed American citizen. The Supreme Court decided the case on other grounds, but we know our brief influenced the court. In their separate opinions, Justices Scalia and Stevens also referred to Hamdi as a presumed citizen. The Hamdi case brief on birthright citizenship is now a permanent part of the Supreme Court records, available to the justices and their clerks. When this issue reaches the Supreme Court, good argument and research will be immediately available. It's already up there in their records. Why is that important? A case the Supreme Court decided in June illustrates just how important an amicus brief can be in deciding the law. The Supreme Court made an astonishing error, all because the court was not aware of a law Congress had passed. Research by the court's legal staff did not uncover this law, nor did any of the 10 briefs filed in the case. Here's what happened. On June 26, the Supreme Court issued an opinion that it is unconstitutional for Louisiana to impose the death penalty for the rape of a child. The court ruled, in its opinion very clearly, that the lack of a federal law permitting the death penalty for child rape showed a national consensus against such punishment. That was a key part of the basis of their entire opinion on this key constitutional issue. But the court was completely unaware of a federal law that does authorize the death penalty for child rape, completely contrary to what they stated. If someone had filed an amicus brief to inform the court of this law, this case may have been decided differently.